What if I told you that the entire debt system runs on legal deception and most lawyers play along? In this video, I'm going to be exposing the 3 biggest lies lawyers tell you about debt, from courtrooms to phone calls, and giving you the exact rebuttals to say when they try to silence your rights. I've helped thousands stand on truth, beat debt collectors, and reclaim their financial power. And this is what they never wanted you to learn. Now, before we dive into this video, this is not legal advice. This is not financial advice. Do your due diligence, okay? I'm going to be talking about how to combat lawyers when they play semantics and things of that nature. More of a part 2 to the video that I did yesterday. So if you didn't see that video, go check out my last video where I talked about unjust enrichment, okay? Now, even though we are going to be giving you some rebuttals and things of that nature, it's important for you to understand the law and understand how to communicate with debt collectors, because and understand your rights as a consumer, because yes, lawyers will try to make you feel dumb. You could be saying the right things, but because you're not a lawyer, they're going to try to make you feel like you shouldn't be arguing whatever it is that you're arguing. That is not true. And if anything, you have more power than the lawyers, because the lawyers are assigned or enslaved to the bar, okay? So there's certain levels and certain policies that they must adhere to that us going pro se don't have to, all right? Now, another thing, if you're brand new, hit the like button, hit the subscribe button. Thank you guys for watching my videos. We just hit 40,000 subscribers. Thank you guys once again. We're going to keep dropping these bangers and hopefully continue to help y'all. Now, what I'm going to be talking about what to say to lawyers is when it pertains to debt, okay? So let's dive straight in. So first things first, let's break down one of the first lies that lawyers will say when they are working on the debt collector side, okay? You owe a debt, so just pay it. To break that down, this assumes liability is established just because your name is on it, and it ignores charge-offs, third-party debt buyers, securitization, and the lack of contract with the current party. So they will start off by giving you and saying, hey, no, you owe the debt, just pay it, but they're just trying to get you to agree. Okay, this is not based off of real facts. This is not really giving you the chance to challenge their claims. This is them just trying to keep it at face value. Okay, this is a form of semantics that they use. Okay, now your response is, who is the original creditor and where's the signed contract with the party currently attempting to collect? And if the debt was charged off, settled, or sold, show the full accounting of all the transactions to prove that there's anything left to collect. Now, when you shift that question onto them, you are shifting the burden of proof onto them, literally saying, hey, look, I'm not saying I don't owe, whatever the case may be, but I need you to prove that I actually owe something. I need you to prove that there's actually something to be accounted for. Okay, because if there's something to be accounted for, if you've already made money or whatever the case may be, I literally have a case to you already being made whole. Okay. If you're trying to make it seem like I have a liability, well, the liability has already been satisfied, given the fact that I've given you my promissory note, given the fact that I signed it, created the value, and you was able to take this and your client was able to take this to the Federal Reserve and exchange it. Not only that, but they also securitize it. Not only that, but they get insured through it. Not only that, but it potentially was charged off. And I want to know if it did, because if it did, then that means that I brought more value to the contract. Am I right or am I right? Okay, so if I already brought that value, then this is something that we never truly got to meet on the minds on. Okay, you told me that your client told me that they was loaning me money, but the reality was that they didn't. Okay, so let's see where this can back you up. When you look at 15 U.S.C. 1692G, which is the validation of debts. Simple, pulling it up for you guys that haven't seen this. Under 15 U.S.C. 1692 validation of debt, you can essentially challenge the validity of any debt. Okay, now this is the protection aspect. So if they say you can't ask these questions, 15 U.S.C. 1692G allows you to ask these questions. Then we go to UCC 9-210, gives you the ability to request accounting of an obligation. Now remember, the obligation is whatever they are saying that you owe. Okay. Then we go to the definition of tender. Tender is to unconditionally offer money or performance to meet an obligation. Okay? So if there was a performance, if you already unconditionally offered money or performance to meet an obligation, and they never wanted to tell you that your performance was originally you signing that contract or that promissory note, your signature was the performance, or you created the financial instrument. And when you release that financial instrument to them and they was able to sell or securitize it, that is you performing on the contract. Okay. And technically it's not even a contract because both parties don't even sign. Have you ever thought about that? They never sign with you. You are signing a loan because it's a bond that you are pretty much giving them authorization to exchange. All right. But they'll never tell you this. They'll make it seem like it's a contract between two parties and we are having an even exchange. But the reality is that's not the case. But then we can also go to understand that the IRS form 1099-C is a taxable event of canceling of debt. Okay. And if debt was canceled using a 1099-C, that means it was settled. So me asking these questions, you saying that I owe a debt, just pay it, really doesn't even open up the floodgates for the other questions that I have about the debt. Okay? Because no, just because you say I owe the debt is hearsay. I want to know the truth. Is that okay? Do I have a right to fair due process? Yes, I do. Okay? So here's the other two. Here's the other lie, and this goes in hand with my last video where I talked about the aspect of unjust enrichment and discharge aren't real defenses. How can you say that unjust enrichment is not a real defense when the restatement of restitution, section 1, pretty much allows you to do that, and also at the same time under 15 U.S.C. 1692E, it's illegal to misrepresent the legal status of debt. Okay? Also, you making it seem like there is no equity or there's no place for equity in modern courts. I love this because under UCC 1-103, UCC 1-103 pretty much says that the equity, principles of law and equity, including the law merchant and law relative to capacity to contract, principal, agent, estoppel, fraud, misrepresentation, duress, coercion, mistake, bankruptcy, and other validating or invalidating causes, supplement its provisions, which it says that the Uniform Commercial Code must be construed and applied to promote its underlying purposes and policies. Okay, so the UCC is set to really simplify certain things. So that's why you won't find certain things in the UCC that pertains to equity. But just this section alone, 1-103, from my interpretation, is pretty much saying that anything that is an aspect of equity actually does supplement the UCC. So that is really not, that's really bullshit. Okay. Keep it a buck. Sorry for my French. Okay. But if a party received payment via insurance, charge off, or securitization and still collects from you, that's considered double recovery, which is unjust enrichment. Okay. So here's what your response would be to that lawyer that tries to claim that unjust enrichment or discharge aren't real defenses. You will say, if the claimant has already been compensated for this obligation, any additional attempt to collect may constitute as unjust enrichment. Please provide proof that the party asserting the claim is the true holder in due course and has not already been paid. This is important because you can act, this is when it comes to a battle of equity, think of equity as equal. Okay, so it should be equal value exchange. They shouldn't get more value. Okay, they should never get more value than they clear and conspicuously disclose to you. If they are, they should just disclose that to you. Because do you think that you would get in a contract where they're able to make money multiple times off of you and you still have to pay them back? You probably wouldn't. Okay. So when I tell you this, obviously these are contracts that we typically get in on a regular basis, but only do that to your discretion. Okay. It's not for you to think that in order for you to maneuver and to keep up with the Joneses, you have to keep getting into credit contracts. You have to get credit. You have to get the new vehicle. You have to purchase a home. You have to do all of these things. Okay. Just be strategic. People get into loans thinking that they're going to go and discharge it too. Don't do that too. All right. You're just like really setting yourself back even further. All right. So I also wanted to talk about UCC 3-604. They try to say that discharge aren't real defenses. Why is discharge in the UCC? It doesn't make sense. Okay. But it's not that you're arguing discharge. Okay. You're arguing the truth about a contract for them to provide proofs. You're arguing for them to provide the proofs. You're not telling them to discharge the debt. You are asking them real questions that have nothing to do with a debt being discharged or for them to reveal that the debt has been discharged. It's not even about that. It's more about, hey, show me the proofs that this is something that you can legally collect on. If you show me the proofs, then obviously I will pay it. Okay? If you can show me the proofs. But if you cannot, then I have a valid reason not to pay this. You have no true reason to enforce this contract because I'm making it about you enforcing this contract. I'm not making it about you zeroing out my account. I really don't care whether you zero out the account. I only care about you coming after me or trying to enforce something you can't enforce. You get what I'm saying? Because if they can't enforce the contract, then whatever obligation there is nullified. Okay? So that dives into 3-604, which essentially says that a person entitled to enforce an instrument with or without consideration may discharge an obligation of the party to pay an instrument by an intentional voluntary act, such as the surrender of the instrument to the party, destruction, mutilation, cancellation of the instrument, cancellation or striking out the party's signature, or additional words to instrument indicating discharge, or by agreeing not to sue or otherwise renouncing rights against the party of the signed record. So them selling the instrument is also surrendering of the instrument. Okay? If they voluntarily sell the instrument, then they have surrendered the instrument, destroyed, mutilated, or canceled the instrument. So that is followed by discharge. Okay? And I haven't even got to the fact that you can send your own tender of payment, challenge them on that. If they refuse the tender, there's discharge under UCC 3-603. Okay? Now, for those of you guys that don't know, UCC Article 3 talks about negotiable instruments, which I will get very comfortable with the different subdivisions and provisions under Article 3. Okay? Also, Article 9, secure transactions, is another one to get well versed on as well. Okay? So let's dive right back into the information. Another thing I want to pull up is, and I didn't talk about this fully in my last video, to talk about the restatement of restitution, Section 1. Restatement of restitution and unjust enrichment. Section 1 establishes the fundamental principle of restitution. A person who has been unjustly enriched at another's expense is subject to liability to make restitution. This means if someone receives a benefit that they unfairly keep, they must return the value of that benefit to the person to whom they received it. So, at its core concept, it means the defendant has received the benefit in a way that is unfair or inequitable, making it unjust for them to keep it without paying for it. Okay, a benefit is something of value that is conferred on the defendant by the plaintiff. This could be money paid for a service that wasn't received, labor, and materials used to improve another's property. If unjust enrichment is proven, the defendant is subject to legal obligation or liability to compensate the plaintiff. This legal remedy that requires the defendant to give back the benefit that they unjustly received. So, for example, if a person pays for the delivery of groceries, but the delivery company never sends them, the delivery company has been unjustly enriched by keeping the money. Okay, Section 1 of the restatement would allow the customer to seek restitution from the company to get their money back. Okay, the purpose of this principle is to prevent unfair outcomes where one party benefits at the expense of another without any legal right to do so. It provides a basis for recovery when other legal theories like formal contract might not apply for or offer remedy. Okay, so now we're talking about the aspect of equity, and this is exactly why they try to shift that conversation. So if I would have broke this down even further, okay, so what does this really mean? When somebody receives a benefit like money, value, or property that they didn't earn lawfully or weren't entitled to keep, and it costs someone else, then equity demands they give it back. That is restitution. It's not about punishment. It's not about proving a crime. It's about restoring balance, okay? Restitution equals restoration of what rightfully belongs to you. So what rightfully belongs to you is the credit that you applied for. So if you apply for 10 grand worth of credit, you should have gotten 10 grand worth of credit. That is the value exchanged. And then if you decided to take the 10 grand to give you to get the vehicle, then by all means, you get the vehicle. But the reality is the vehicle is more of a benefit for the cost of doing business with you. Okay? How this applies to debt collection and discharge. Let's say a lender charges off your debt and takes a tax deduction 1099-C. or the debt is paid by insurance or pulled into a security. Then they sell the debt to a debt collector for pennies, and now the collector sues you for the full amount. That is unjust enrichment. I just explained to you 4 ways that they make money off of the original debt if you were to default, and then they still come after you for the full amount when they sue you in court. That is considered unjust enrichment. Why? Because they're trying to collect the value that they already recovered elsewhere. Okay? So they can't double dip. Once the obligation has been satisfied by any party, they no longer have lawful claim to enrichment. All right? It will make sense if they never got the money and they couldn't get the money. But if you're going to get the money, that would be considered immoral or unequitable for you to still try to come after the money. And it's so funny that they don't even do that deep diving and digging before one tries to sue them. It's up to you to do that. So if you think of like a real world example, imagine you drop off a package at a courier, you paid in full, but then the second courier who didn't deliver anything shows up and demands you to pay again for the same shipment. You to say, no, it's already been paid. You didn't perform anything for me. The same thing with debt buyers. They didn't loan you money. They didn't take a risk, and they just bought paper and now want profit. That's the key. The fact that the bank never loaned you anything, nor can they prove that they own you anything, meaning that they are keeping value that they shouldn't be keeping. Okay? When a debt collector or servicer demands payment, you will say, I have reason to believe that the obligation has already been satisfied, charged off, or securitized. If the party asserting this claim has already received payment from any third party settlement, insurance, or tax offset, then any continue to collect on this constitutes unjust enrichment. Under the Restatement of Restitution, Section 1, this creates an obligation of restitution, not collection. So technically, you should be giving me money back. Okay? You shouldn't be asking for more from me. Okay? Here's some other legal concepts that support it as well. A constructive trust. Court can force them to hold those funds on your behalf if unjustly enrichment incurred. Quantum merit. If they didn't perform any actual service for you, they are not entitled to compensation. So this pairs really well with debt collectors, lawyers, third-party debt collectors who are reaching out to you when you say that there is no contract. You can go even further and say that, hey, you guys never actually gave me a service. I don't care who you bought the debt from. Equitable estoppel. If they accepted satisfaction but now deny it, they can't flip-flop their claim. Okay? So even because I do have one of my clients that they sent in a gold check for $60,000. They pretty much accepted it, but they reversed it. That would be a good argument. Equitable estoppel. But here's the mindset that you need to have. Okay? Unjust enrichment isn't just legal, it's spiritual. You can harvest what you didn't plant. And if someone is profiting off your energy after the debt has already been paid, then remedy isn't optional. It's actually demanded by natural law. Okay? So as we push further, another lie that they'll tell, because now we just overcame the aspect of unjust enrichment. Another lie that they'll tell is that you can't say that in court. Okay? It's very funny that they'll say that you can't say certain things in court, because this is probably one of the most dangerous lies at all. Okay? You're in court, prepared, you've studied, you got evidence, and you're ready to speak facts. And what do? They say that that's not relevant. They say this court doesn't recognize that. They say this isn't a sovereign citizen hearing. Stop bringing up the UCC, discharge, or securitization. We're not here for that. That's not law. That's legal theater. Okay, they're trying to make it a game. They're trying to make it a show. Okay, but here's what they're really saying. You're not a part of our club, so your truth isn't valid here. They're gatekeeping, and they want you to feel powerless, so you consent by silence. Once you hear that, you stop arguing. Okay, but here's the truth. Due process means you have a right to speak, present evidence, and challenge standing and rebut assumptions. I don't care what anybody says. Don't ever let anybody tell you you cannot speak or state your claim or have an argument in court, because you have a right to due process. Okay? So they don't get to cherry pick which part of your defenses are allowed. You get what I'm saying? Now, here's why this tactic works on most people. Most people walk into court already believing that they are the debtor. They already assume the court is neutral, and they already doubt themselves. Okay? Just know it is an uphill battle. Okay? But I don't say that to discourage you, but I say that so that you're well prepared. to have all your evidence to the point where if you're going to climb up a hill, you're going to climb up a mountain, what you're going to literally do is you're going to make sure that you are well prepared. Okay, you're gonna make sure you don't have that many items on you, or whatever the case may be. You're gonna make sure that you have less weight on you. You're gonna make sure you have water. You're gonna make sure you have everything that you need while you climb that mountain, the stick or whatever. You're gonna make sure you're well prepared. Okay, to the point where yes, you may see that tall mountain, but you already know what to expect. Okay, so when a judge or opposing counsel say you can't say that, they freeze. Because you're not most people. You're not asking for permission to speak truth. You are demanding remedy. You are demanding your truths. Okay? So here's what the law actually says. Under the 14th Amendment, due process clause. You have a right to be heard, to present evidence and rebut any claim made against you. I don't care who it is, who they think they are. Not even a judge. Okay? Also, UCC 1-103, what we just talked about, it says the UCC is supplemented by principles of equity, justice, and good conscience, including fair dealing, restitution, and commercial reasonableness. So again, if they try to say you cannot speak any equity in this, or whatever the case may be, under UCC 1-103, equity supplements what it is I'm talking about right now. So yes, it does apply. I shouldn't even have to teach you guys this because you guys know this already. Okay, and they're going to challenge you. They're going to make sure you know what you are talking about. Okay, UCC 1-308, you can reserve your rights without prejudice, even while participating in the court process. So yes, you can speak on standing. I don't care what they say. You can speak on discharge. You can speak on an improper incitement. You can speak on a proof of claim and challenge them and ask them for proofs. You can ask them about equity, and equity does apply when it pertains to the UCC. You can challenge them using the tender of payment, and you can challenge and bring up unjust enrichment. Don't ever let them say that you cannot do this, because the moment they stop you from presenting, they are violating due process and not following the rules. All of this is going to be on the record. If you ever get in a situation, for the record, are you saying that I don't have a right to due process? I don't have a right to speak? I don't have a right to present my evidence that I have? And you're just going to force me to pay this debt? I just want to say it for the record, okay? Because even if you do lose, you can appeal, and this will be on the record. Speak clearly, okay? What to say when they try to shut you down. Be calm, firm, and make sure you are telling them that what you are saying is on the record. For the record, I object, and I reserve all my rights under UCC 1-308. I'm not here to argue. I'm here to state facts, rebut presumptions, and preserve my rights. I have material evidence relating to standing, assignment, and discharge of the alleged obligation, and I respectfully request that it be entered into the record and considered in full. Be firm and calm. Don't yell. Don't be disrespectful. Because at the end of the day, the way they act is going to really truly show the type of courtroom it is. Okay, and the fraud and the shame and the scandal is going to be pretty much like presented in the facts on the record. If they try again, respectfully, I am not permitted to challenge the validity or standing. If I'm not permitted to challenge the validity or the standing of the claim being brought against me, this is not a fair hearing. That will constitute a denial of due process under the Constitution. Now, you have asserted your rights, you have triggered liability, and preserved the record for an appeal or counterclaim if they don't want to hear you out. Okay? Even if they still ignore you, you are no longer playing the role of the debtor. You are now the one documenting dishonor. You can also hold the courts accountable too. Okay? So, here's how you can really game plan just more of a bonus. How to be heard even when they silence you. Bring everything that you're saying in writing. What I am talking about, put this in writing. Submit this in evidence. Okay? Write an affidavit of truth. Have your notice of tender with discharge. Take them through the administrative process using conditional acceptance. Challenge the standing. Make the record. Speak clearly. Let the record reflect that I attempted to enter material evidence and was denied. Use their dishonor later. File a complaint, motion to vacate, or counterclaim for due process violations. They might win that day, but you have set up your next move. You always can position yourself for your next move. Sometimes going to court is the setup. Sometimes even doing this positions you to be able to negotiate better. Because when that lawyer on the opposing end sees how serious you are, sees that you know something, they're going to be like, okay, bet. This person might actually pull this along. This person might actually try to appeal. This, that, and the third. Okay? So you don't need a role to speak the truth. You don't need to be an attorney. Okay? To study the law or represent yourself. You don't need a license to challenge fraud. You don't need permission to assert your rights. And all you need is your words, your paper, your presence, and in honor, in truth, and in control of your energy. If you move like that, then you are going to be able to get the proper results that you want when it pertains to this. This is not an easy battle. I'll be honest. I'll be upfront. This isn't easy, okay? Which is why I tell people to be okay with taking their time learning the information. Okay, some of you guys watch my videos and your back may be against the wall, but one of the quotes that I've heard and why I talk about this game now is because it's best to do this stuff while you are comfortable than when your back is against the wall. Because when your back is against the wall, you rush, you make mistakes, and you do things like that. Trust and believe. Try not to do that. Try to do things when you are comfortable, whether it's learning, trying to get well versed, maybe starting small on a debt collector or whatever the case may be. Those debt collectors are easier to challenge, okay? If it's something charged off, you really have something to stand on that it's already been charged off, okay? Now, thank you guys for watching this video. If you want to learn more about this, tap into the school community. The school community, you can get in for a 7-day free trial. If you like it, great, you can stick around. If you don't like it, you can cancel it. Number 2, if you want to work with me one-on-one, specifically on fixing your credit, getting funding, tap into the one-on-one mentorship. The link will be in the description down below. I only work with people that are serious about building their credit, getting funding, okay? And it is a premium coaching experience, so yes, it does cost money to work with me. If you're gonna get on the phone and ask for a handout, I probably won't be able to help you, okay? Respectfully. And then lastly, if you're brand new, hit the like button, hit the subscribe button. Make sure to turn on the post notifications because you are the creditor. You are the person who has the control. You are in power. All right. Thank you guys once again for watching the video. I love you guys and I'll see you in the next one. This video is sponsored by the Fund Yourself Academy. My step-by-step system designed to help you fix your credit, get funding, and build real financial freedom from scratch. If you're tired of feeling stuck, overwhelmed, or just ready to stop living paycheck to paycheck, this is where it changes. Inside the Academy, I break down everything from consumer law secrets that they don't teach in school to how to remove negative items and boost your score, get access to business funding, and start building multiple income streams online. Whether you're just starting out or ready to level up your game and get the bag, this is your playbook. We've got tools, templates, dispute letters, mentorship calls, private community access, and an exact roadmap I use to leave my 9-to-5 and create time freedom. But only for a limited time, you can get access to the Fund Yourself Academy on a free trial basis for the next 7 days. And then after that, you pay less than $1 a day at $27 a month if you like it. No fluff, just facts and just freedom. Go to the fundyourselfacademy.com or hit the link in the description to join now because nobody's coming to save you, but you can fund yourself.